The three new criminal laws' aim is to overhauling the whole criminal justice system. Home Minister Amit Shah highlighted one of the key changes during his speech in the parliament, emphasizing the newly established timelines for conducting trials and delivering verdicts by the court. The recently enacted Nagrik Suraksha Sanhita sets a specific timeline of 30 to 45 days for pronouncing a verdict in a criminal trial. The bill states that after hearing arguments in pointing of law, the judge shall give a judgment in the case as soon as possible within 30 days from the date of completion of arguments, which may be extended to a period of 45 days for reasons to be recorded in writing. Currently, the Code of Civil Procedure mandates that courts must take every endeavor to pronounce a verdict within 30 days from the date on which the hearing of the case concluded. It also establishes an outer time limit of 60 days for the courts to pronounce a verdict from the conclusion of arguments. Section 353 of the Criminal Procedure Code prescribes that the verdict should be pronounced either immediately in the open court or at some subsequent time. In 2001, the Supreme Court issued a verdict reprimanding the subordinate courts and recommending a timeline of between 6 weeks to 2 months for pronouncing the judgments. However, these timelines have often been disregarded. Both the Supreme Court and various high courts have consistently noted that delays in the pronouncing verdicts erode the trust of common man in the judicial system. In May of this year, a Supreme Court bench issued detailed directions to expedite the trials and directed high courts to transfer the trial for re-hearing to a different bench if a verdict was not pronounced even 6 months after the conclusion of arguments. During the Lok Sabha debate on the bills, Home Minister Amit Shah stated that either there was a significant time gap between the judgment and the sentence. We have ensured to reduce this. Moreover, the Bharatiya Nagrik Sanhita has also been established a timeline for discharging the person accused in a case if the complainant fails to appear in the court. When the proceedings have been instituted upon complaint and on any day fixed for the hearing of the case, the complainant is absent and the offence may be lawfully compounded or is not a recognizable offence. The magistrate may, after giving 30 days time to complainant to be present in the discretion, notwithstanding anywhere herebefore contained at any time before the charge and has been framed, discharge the accused. The existing CRPC does not specify timelines for issuing notice to the complainant or initiating the procedure for discharging the accused in such situations. Under the CRPC, the procedure and the timelines are left to discretion of the magistrate. The three bills passed in the Lok Sabha, Bharatiya Nyaya Sanhita, Bharatiya Nagrik Suraksha Sanhita and Bharatiya Saksha Sanhita that aims to replace the Indian Penal Code, the Code of Criminal Procedure and the Indian Evidence Act, respectively. This is Meera Verma for Legally Speaking.